This is a socio-legal paper, so you might see some jargon which is purely legal, but I'll try to explain as much as possible in social terms. Bismillahir Rahmanir Rahim. Honor killing, as we all know, is a highly charged, emotive, and rather notorious issue that is commonly understood or portrayed as violence mainly against women. In this context, such killings relate to a practice in which women are murdered by their male relatives to restore the honor they lose when their women defile it. Generally, it is held that women severely injure a man's honor when they fail to guard their virginity and chastity. Such a construction of honor is based on the studies conducted in contemporary Muslim societies. The issue of honor killing in this era are being projected and studied widely as a vice that plagues Muslim societies. They forgot to observe that honor killing are as old as the dawn of history, since all the written legal codes mention severe punishment for adultery. It has prevailed at all times. It knows no religious, cultural, racial, or territorial boundaries. For instance, in India, the law of Manu, the legendary lawgiver of ancient India, laid down that an adulterous wife should be torn apart by dogs. And I have, I think, one page from law of Manu here. So the wife should be torn apart by dogs. The law code of Hammurabi, which is of 1780 BC text, laid down that the adulterous wife and her paramour are to be drowned. In Assyria and Sumerian law codes, adultery in women was a capital offense. In the Julian marriage laws, fathers were permitted to kill daughters and their partners in adultery. Modern scholarship quite intelligently makes distinctions between the killings in the name of honor and a killing under passion. In fact, France recognizes that and has a law known as a crime passionné, crime of passion. Non-Muslim countries such as Britain, Norway, Italy, Brazil, Peru, that are also infected with these diseases, this disease do not draw as much media and scholar attention as does the Middle East and South Asian states. Among South Asian countries, the cases of honor killings in Pakistan are often presented and quoted as an archetype of the problem of honor killing by a number of authors and non-government organizations. This paper demonstrates that not only the cases of honor killings in Pakistan are typical of problem cutting across all Muslim countries, but also that the treatment of the offense and the offender reflects to a certain extent the various currents of thoughts flowing in the minds of Muslim intellectuals. I shall also examine the treatment of the issue of honor killings under the law of homicide and murder as was enacted by the legislature of British India. It is argued that a century-old legal tradition laid down by the British during their rule over the subcontinent, which accommodated such killings with leniency, not only structured, strengthened, and cemented this cultural practice, but also transformed this social norm into a legal defense. This social norm was dealt with leniently under the plea of grave and sudden provocation under exception of Section 300 of the Indian Penal Code, which was drafted in 1860. In this paper, I argue that the issue of honor killing is closely linked with the conflation of two concepts, sin and the legal concept of offense, which I think still is a big problem for all Hausa students and other students. The implication of the commission of a sin with the consequences of commission and offense has caused a lot of confusion among judges of various courts and the intellectuals of the Muslim world. In Islam, fornication and adultery are sins. as well as offenses. However, these wrongs or licentious acts remain sins unless someone proves the commission of these acts or wrongs against the accused in a court of law. Once these wrongs and sins are proved in court, then they become offenses. And then they are punishable. That is, thus, it is this is the inavailability of the evidence or acceptance of evidence means that these acts remain sins and are not to be counted as offenses. This research sheds light as to how courts confuse these two independent, simple and straightforward legal issues of Islamic law while interpreting the Islamic law of homicide and murder, the law of qisas and diyat, which is qisas means retribution, diyat means compensation, the law of retribution and compensation. I have argued that a complication has been caused by the sum of the common law trained judges who incorporated the social, cultural and legal norms of the English law into the Islamic law. This was a definite appropriation of the Islamic law by the judges trained in the Western legal tradition to bring in their own understanding of Islamic criminal law, old Western legal notions and self-structured concepts of ghairat. I don't find a equal translation for ghairat, which is loosely translated as honor. Also the word izza, I have given here dictionary meanings of both, izza and ghairat, but they are both loosely translated as honor. Islamic criminal law deals with the offense of zina. Again, there is a big problem on the definition of zina, what it means. It is fornication as well as adultery in quite a distinctive way as compared to other offenses. Under Islamic law, if one complains that someone has committed fornication or adultery and subsequently fails to provide the required evidence in court to substantiate his or her statement, the complainant is charged under the offense of qazaf, which means lying or to put blame to someone. Another Islamic offense. The complainant is made liable to the offense not because he or she told a lie, but because he or she failed to prove his or her allegations in court. He or she may say that 3 witnesses might have seen the commission of the offense in actual, but since evidence is insufficient to prove this and convert sin into an offense, the complainant should therefore either remain silent or face the charge of lying, which means qazaf. The only exception to this rule is a husband who sees his wife committing adultery but is unable to provide the required evidence of her wrong in a court of law. Such a husband would not be charged of qazaf. For qazaf, such an allegation against his wife supported with special oaths would enable the court to separate the pair under the doctrine of lien. This again, when I was coming here on train, I was thinking of this particular concept of lien, wherein both parties go to court and take oaths that this has not taken place. Even here, Islamic law or Quran does not give a right to husband to beat the wife, as it said that husbands are allowed to beat the wife. So in this very severe critical situation, when the husband sees a wife committing adultery, a husband is not allowed to beat the wife, rather he is allowed to go to court and take an oath and divorce will take place. While drafting the penal law for India during 1835 and 1837, the members of the first law commission sympathized with those men whose honor was violated if someone had sex with his wife or sister. Therefore, they suggested that if a man finds someone having sexual intercourse with his wife, daughter or sister and kills the man, women or both, such killing should be termed as a murder. but should not be termed as murder, but should be reduced to manslaughter. The Commission observes, we think that to treat a person guilty of such homicide as we would treat a murderer would be a highly inexpedient course, a course which would shock the universal feelings of mankind and would engage the public sympathy on the sides of delinquent against the law. Nevertheless, they were in favor of punishing such men whose honor, this is the first time this word was used, whose honor was injured, in order to teach them to entertain a particular respect for human life. It ought to be punished in order to give men a motive for accustoming themselves to govern their passions. The Indian Penal Code went further than the English or the French law, as was in currency under that time. The Indian Penal Code showed indulgence to homicide, which is even the effect of anger excited by words alone. Explaining the rationale behind this law, English Law Commission wrote, one outrage which wounds only the honor and affections is admitted by Mr. Livingstone to be an adequate provocation. A discovery of wife of the accused in the act of adultery with the person killed is an adequate cause. We conceive that there are many cases in which as much indulgence is due to the excited feelings of a father or a brother as to those of a husband. That a worthless, unfaithful, and tyrannical husband should be guilty only of manslaughter for killing the paramour of his wife, and the affectionate and high-spirited brother should be guilty of murder for killing, in paroxysm or rage, the seducer of his sister appears to us inconsistent and unreasonable. For them, such an assault may produce Sicilian vespers and call forth the blow of war of Wat Taylor. One who deprives a high-born Rajput, a caste regarded high in Indian subcontinent, of his caste, or rudely thrust his head into covered palanquin of a woman rank may also enrage men to such an extent that the violator may be killed. Thus, such homicide cannot be equated with murder, and the perpetrators deserve to be dealt with leniency. Although it is difficult to envisage with certainty as to what definition of or criteria of honor was in the mind of the framers of Indian Penal Code, it appears to be very similar to the one given by John Elster, according to which honor is an attribute of free, independent men, not of women, slaves, servants, or other small men. The later can, however, as we shall see, be very much concerned with honor. It is achieved or maintained by victories over equals or superiors, where victory can mean anything from getting away with an insulting look to raping a man's wife or killing him. It is not the case that the British were unmindful of the fact that the law ultimately served the purpose of setting up new and positive norms in society and exhorts people to tune their passions in obedience to law. Perhaps it was a matter of priorities. What answers do we have for a question that the same provision of grave and sudden provocation did not give concession to a person who killed a public servant on duty, though his act might have caused equally grave provocation? For instance, a male official doing a body search on the females of a Rajput family is bound to provoke the same feelings that a stranger may stir up with when he takes indecent liberties with the women folk of that Rajput family. The clear reason, perhaps the only, could be that the public must teach themselves to keep their emotions in control when they deal with the servants of the crown. However, in other cases, if she or he loses his self-control, that is quite understandable, and he or she will be punished under the charge of manslaughter and not under the murder. For murder, killing the one who commits adultery with someone's wife is something which Muhammadan law also is indulgent, wrote the authors of Indian Penal Code. Their understanding of Muhammadan law was perhaps based on the fact that under the Islamic criminal law, as practiced in India prior to the promulgation of the new regulation or the Indian Penal Code, a person was not liable to qisas, retribution, if he kills someone who is found committing adultery. Taking support from this provision of religious law for the enactment of secular or for that matter, a neutral code was not only inapt but a misconception of the tenets of Islamic criminal law. Under the Islamic criminal law, adultery is an offense, punishable with death as a had. Therefore, as the Muslim schools of thought agree that a had, which means limit or boundary, can neither be delayed or remitted, the killing of a married adulterer is obligatory as well as indispensable for eliminating evil and enforcement of the laws laid down by Allah. Anderson has also written that a father or brother who surprises his wife, daughter, or sister in adultery is exempted from the penalty if he kills her or paramour or both. We shall discuss the legality of the issue of adultery in Islam at a later stage, but suffice to say here that killing the one who is found committing adultery under Muhammadan law was not an act to restore the honor injured by the adulterer, as anyone may kill such an adulterer, not necessarily a definite person, husband, father, or brother, to the exclusion of others. The killing under the Islamic law is done in discharge of the duty bestowed upon him as a Muslim. However, there is a dispute among jurists whether such a person would be liable for ta'zir on the ground of encroaching on the powers of competent authority or not. In the famous case of Said Ali versus Empress, and this is 1890, reported in 1890, the division bench surveyed all the case laws of India since the promulgation of Indian Penal Code in 1860, wherein various high courts reduced the charge of murder to culpable homicide by reason of proof of exception 1 of section 300, which means grave and sudden provocation. These were cases wherein the accused had killed the paramour or wife or both. They had been awarded sentences from only 8 months to 10 years. The bench complained that in none of the cases was a principle laid down explaining the reason for awarding various sentences. Beside this, the bench referred to some unreported interesting judgments wherein sentences were delivered taking into account the tribal values of the accused. Among them is one whereby a session judge had awarded 10 years imprisonment to an accused who had killed the deceased on being only found in the accused's house. According to accused version, the deceased had come there to visit a woman of his immediate family. The appellate court, reducing the imprisonment to 2 years, wrote, "It is hard to say that any excess where the provocation received is of the grave and sudden character, as disclosed in this case, an entry in the night into the house of accused must bring severe retribution. A Pathan with his blood justly roused could hardly be expected to show much moderation." So he reduced 10-year sentence into 2-year sentence. The bench referred to 2 judgments of the Peshawar Appellate Court wherein the judges found 2 years imprisonment adequate if the accused had lost his self-control, finding his wife in merely objectionable position with the deceased, lying together in the same bed. The court quoted the following paragraph from a judgment delivered by the additional session judge Peshawar for a similar offense. "I think myself that when the defense is accepted that a man has justifiably lost self-control and acted in accordance with the natural dictates of human nature, when not under the control of reason, severe punishment is not called for. And this is especially true when the offender belongs to one of those effrontery races and in taught from his cradle that dishonor to his women folk calls for immediate and bloody revenge. Though the act done is not by law justifiable, as the offender may have supposed, it is held by the law to some extent excusable. And I think that a man who is in his own estimation is not morally culpable and whose view is shared by the most, if not all his neighbors, a sentence of 2 years rigorous imprisonment is substantial punishment for an offense committed under such circumstances, wherein the law regards it as an excuse. This practice of awarding lenient sentences in cases of honor killing became very popular among lawyers. The accused did not feel any dishonor even in bringing their wives, sisters, and to the witness boxes to admit before the court that she had an affair or relationship with the deceased, or for that matter, she was committing sexual intercourse with the deceased when the man in charge of her killed him. The courts did not show any surprise over the honorable accused who brought in their honors to court to testify and reveal about the dishonorable act they were indulged in, so that they may get away from the lesser punishments. After the partition, this was all by English judges in the subcontinent. So after the partition, when Pakistan was severed from India, they adopted the same penal code, but its name was changed from Indian Penal Code to Pakistan Penal Code. They continued with the same practice. In a case reported in 1950, the Peshawar High Court again referred to a cultural characteristic of a cultural norm of a particular race in appreciating the loss of self-control of a person in a particular society, the court observed. In that part of the country where a mere casual talk by a woman with a stranger is looked upon by the relations, and that in particular the husband of the women, as well as the society, with great disapproval and resentment, the actual act of adultery may excite feelings incapable of being explained in words. However, the turning point came in January 1988, when the Shariat Appellate Bench of the Supreme Court of Pakistan took up 11 Shariat appeals together for hearing. Among them were 2 appeals submitted by the federal government of Pakistan. And in these appeals, they challenged the concept of grave and sudden provocation under the Islamic law, and to test whether this provision or concept of grave and sudden provocation is an Islamic concept or not an Islamic concept. So the Shariat Appellate Bench took up these 11 appeals, and they unanimously decided in these appeals that the concept of grave and sudden provocation has nothing to do with Islam. And Islam does not promote or accept any plea which is taken by the accused when he sees his wife or sister with a paramour and allows him or permits him to go and kill them. And if it is done, then this person must be charged with murder, and only murder, and there should not be any concession given to such murderers. However, because in Pakistan, as you might know, most of the judges are trained under common law, English law. They are mostly barristers. They have come here, they study here law, and then they go back. So that's why this plea of grave and sudden provocation was still in their mind. They were still thinking in those lines. So in 1992, before the Supreme Appellate Court, where these mullahs or the Shariat trained judges do not sit, they, in a case called Muhammad Hanif, they decided, Justice Shafiur Rahman decided, the punishment of qisas, which is retribution, is general in its application. However, one is liable to qisas only when he kills someone who is not liable to be killed, meaning thereby he or she is masumud dam, which means liable to be killed, whose blood is forgiven, and that he is killed intentionally. It means that qisas is liable only in case of intentional murder. So despite the Shariat Appellate Bench's very lengthy judgment wherein they dealt with the issue, I think on 200 pages, he came to the same conclusion, this judge, and says no, because within Islam, there is a plea, there is a person who is masumud dam, which means whose blood can be who can be killed, and blood is forgiven. So if you kill that person, and the person who kills this person, this murderer, should not be given the same punishment because he killed someone who was supposed to be killed in any way. So they took again the same plea. So the court further held, if we go by the strict injunctions of Islam, we find that punishment of death is permissible where under had the offense already committed or sought to be committed by the person is liable to had by death. And because he argued that in case of zina, a person, or adultery or fornication, a person is liable to be given a death penalty. So if this person kills this person who is liable to be given death penalty, this murderer should not be given the same sentence. So the court said the murderer should not have taken part in the exercise. However, again another court says that the said murder should not have taken place in the exercise of the right of self-protection. Quoting 3 ahadith from the Prophet ﷺ from a collection of ahadith, the court advanced a new theory, and this is very interesting. It held that amplitude of the right of self-defense under the injunction of Islam is far wider than it is available under the Pakistan Penal Code. So, in the Penal Code, the provision was only available under the concept of grave and sudden provocation. However, this judge now is expanding this theory and trying to find from Hadith to support his argument and saying that such person should have been killed and this murderer should not be given any punishment. So he writes 3 ahadiths which are important to quote here. Abu Huraira said he heard God's messenger saying, if one were to look into your house without receiving your permission and you were to throw a pebble at him and put his eyes, you would be guilty of no offense. So this is one hadith he quoted from Bukhari. Sahal bin Saad said that a man looked through a hole in God's messenger's door when God's messenger had a spike with which he was scratching his head. So he said, if I knew that you were seeing me, I would poke it into your eyes. For asking permission has been appointed only on account of what people may see. So this is again Bukhari and Muslim. And thirdly, Abu Zar reported God's messenger saying, if anyone removes a curtain and looks into a house before receiving permission and sees anything in those within which it should not be seen, he has committed an offense which it is not lawful for him to commit. If a man confronted him when he looked in and he puts his eyes out, I would not blame him. But a man passes a door which has no curtain and has not shut and look in, he has committed no sin. For the sin pertains only to the people inside. So this is from Tirmizi. Consequently, the court dismissed the state appeal and upheld the judgment of the trial court, again not under the concept of grave and sudden provocation, but on the basis of these 3 collection of ahadith. Closer examination of these judgments show how selectively these judges use the Quran and Hadith, endeavoring hard to make their own notions of law of the land. They used some legal words like masumuddam, ghaire masumuddam, which means whose blood is not forgiven, verses of the Quran and sayings of the Holy Prophet very loosely without adverting to other relevant Quranic verses and sayings and practices of the Prophet which contradict their own constructions of the selective material. We shall deal with Islamic interpretation of the issue later. However, we would only mention that these judges use the Quran and Sunnah to justify the action of the accused, the murderer. They did not mention the principles laid down in the Quran and Sunnah that deal with the law of the acceptance of an accused assertion or the law which provides defense to the accused. The issue was further complicated by a judgment of the Lahore High Court, wherein a judge gave again, I think, 2 ahadith of the Prophet ﷺ, and these are important ahadith as well. Sahal bin Abeda, because they make the legal basis for further law. Sahal bin Abada says, if I found a man with my wife, I would kill him with the sharp side of my sword. When the Prophet heard this, he said, do you wonder Saad's sense of ghaira, which again means honor, loosely translated? Verily, I have more sense of ghaira than Saad, and Allah has more sense of ghaira than me. Allah's apostle said, none has more sense of ghaira than Allah, and for this he has forbidden shameful sins, whether committed openly or secretly. And none loves to be praised more than Allah does, and this is why he praises himself. Another hadith is Abdullah bin Masud: none has more sense of ghaira than Allah. Therefore, he prohibits shameful acts, whether committed openly or secretly. And none loves to be praised more than Allah does. For this reason, he praises himself. I asked Abu Wali, did you hear it from Abdullah? He said, yes. I said, did Abdullah ascribe to Apostle? He said, yes. Again, on the basis of these ahadith, they legitimized this killing and allowed the murderer to go away from any punishment. However, later again, in Karachi High Court, a judge says, cites another important hadith, which is from Hilal. And it says, Allah revealed the following verse in the Holy Quran: and for those who launch a charge against their spouses and have in support no evidence of their own, their solitary evidence can be if they bear witness 4 times by Allah they are solemnly telling the truth. And the 5th oath should be that they solemnly invoke the curse of Allah on themselves if they, this is the lian thing, wherein a wife and husband, because it is very difficult to find an evidence if a wife is committing an act of adultery. So he cites this example of the Prophet, that a man goes to the Prophet ﷺ and says, I have seen my wife committing adultery. He says, bring 4 witnesses. He couldn't bring 4 witnesses. So he said, no, you have to bring 4 witnesses. So this verse in the Quran was revealed, and the verse allows that this man should be asked to take oath 4 times, a special oath that he has seen his wife commit adultery. And again, the wife was asked to take the same oath in presence of the Prophet ﷺ. So wife takes the oath, and the Prophet ﷺ dissolved their marriage. So this judge relied on this and said, interestingly, both Hilal and his wife took oath prescribed in the Quran. Hilal in support, whereas his wife denial of allegations. On this, the Prophet decreed separation between the spouses. On conclusion, the Prophet further said, see the woman, if she brings a child with eyes the color of antimony, large buttocks and fleshy legs. It is from Sharik bin Shams, because this is the man, the husband complained that he was having sex with his wife. Then the women brought forth such a child, and the Prophet said, verily, had there not been an order about this in the book of God, I would have done with the women what I would have done. In this backdrop, Justice Muhammadi says, the hadith which previously I just narrated, these hadiths were not reliable and should not be made the basis for providing exception to such murders. The Supreme Court of Pakistan once more constituted a full bench comprised of 7 judges, this time larger than the previous one, and then they examined the issue of grave and sudden provocation and quoted extensively from an article written by Professor Rafiullah Shahab, a famous Islamic scholar. In this article, the professor had declared that there was no concept of so-called honor killing in Islam. Relying on the judgment, judgments of the Prophet wherein he separated the spouses who had sworn that their partner had an illicit affair. The court quoted, killing accused women is not Islamic by any standard. The believers are not even allowed to divorce them without establishing their accusations. We profess our love for Islam and demand its enforcement in the country, but ignore clear Quranic injunctions about the rights of women. Dozens of innocent Muslim women are slaughtered in the name of honor in our society. Almighty Allah eliminated the evil of Jahiliyyah period, and thus no case for honor killing was reported in the early time of the Holy Prophet ﷺ. On the basis of this, again he says that before Islam, women were treated as a commodity, but Islam granted them equal rights. But even in 2001, the men in our society enjoy a special status. However, instead of making term generous, this professional treatment serves a deep-rooted contempt for the female sex, whether it would not encourage cold-blooded murder, double murder in the garb of honor killing, and violence against the women. Despite the fact that in the most of the cases, act has been misused to gain property, demanding the hand of a woman of choice, settling the old scores, and personal vendetta. Also, whether licentious shown by the courts, leniencies shown by the court have not substantially increased the killing in the garb of ghairat. We have no option but to believe it because there is no other evidence to contradict part of this statement, maybe due to his incompetency and inefficiency of the investigation officer or people who do not come forward. Interestingly, the judiciary of Pakistan, irrespective of its competence, power, and sometimes even jurisdiction, has always tried to fall back on Islam and its sources to justify their reasoning in their judgments. Even more interestingly, the judge's point of departure has always been their own interpretation rather than the Quran and Sunnah by the different schools of thought. So I concluded, the way to end honor killing is not through courts of law. The researcher agrees with Shaheen Sardar Ali, chairperson of the National Commission of Pakistan's point that the practice would not go away until men stop thinking women as their property. The author contends that in a patriarchal society like Pakistan, the attitude and thinking of men towards a woman needs to undergo a vast change, and only then it would be properly reflected in the decision of the courts. New legislation may help, but will not eradicate the problem in a few years. Centuries-old norms that are integrated part of thinking process of men in society will require time. Thank you.